When you're thinking about the assets of a marriage, it's like looking at a fruit bowl with all different kinds of fruit. And sometimes when you're dividing an asset, it has a tax consequence. A dollar in your savings account is not the same as a dollar in your IRA. And when you have a complex asset that later monetizes, that asset is going to have a tax consequence. Oftentimes, the tax consequence is withheld. If in the instance of a restricted stock unit or stock option, the firm itself may withhold taxes in order to pay withholding on that distribution. But oftentimes they are under withheld. And so what are you going to do if later on, let's say you get $100, you divide it, one person keeps $80, the other person keeps $20, and now we've got a $10 tax bill. What are we going to do about that? Whenever we're dividing complex assets, we need to get really clear on how we're going to handle the taxes and how it's going to be trued up. It's really important when you're getting divorced and dividing the assets that you take into account the income streams from all assets. Now, not every asset has an income stream, but many of them do. Not every income stream is immediately available. Making sure that you have an accurate, complete, total picture of what income is going to be available to both of you in the future as well as today is crucial to the best result. So when you're getting divorced, one thing that you need to get to before you can start negotiating is basically a shared understanding of your economic reality, but that's not always so easy to do. You might have a real disagreement about what something is worth. It could be something so simple as your house or vacation property. One appraiser comes in and says it's worth X and the other one says Y. What are you going to do about that? When it comes to business valuations, wow, you could get a really big variety between what one expert says and what another one says. What are you going to do? In litigation, well, a judge is going to decide. And in New York, a judge can't just split the difference. The judge has to make a decision. This person's expert is right or that person's expert is right, as if they really have the experience or the skill to do that. So really, it's going to be on you to find some kind of resolution that makes sense. Maybe in the case of a real property, you wait and actually sell it because that's what it's worth, what you actually sold it for. Or maybe we put in some parameters around a business valuation. And if it turns out to be much better than or much worse than what we have valued it at, there's some kind of kicker or later term that comes into place to help even it out. There are two ways to handle complex assets. One is to value the asset today and distribute a portion to the non-titled spouse, and the other is to take an if, as, and when approach, that when that asset monetizes, it will be distributed. Overwhelmingly, people generally choose the if, as, and when approach because it's more accurate. The risk is taken away because when it monetizes, it will monetize at whatever the dollar value it is. We'll account for the taxes and then distribute a portion of that to the non-titled spouse. But when you take an appraisal and you look at what the appraisal is, appraisals are art and science. And what approach any particular expert takes is different from expert to expert. And people often disagree. My expert said more, your expert said less. What are we going to do about that? Judges can't split the difference, but you can. Judges can't go out and get another one and another one and another one appraisal, but you could. You need to find a way to bridge the gap in a way that makes sense for both of you. If you want to avoid some of these common pitfalls while dividing complex assets in a divorce, please give us a call at Miller Law.